Good afternoon to everyone. Thank you for the presentation. I'm happy to be here with you to present the situation, the legal situation of marriage and family at the European level, which unfortunately is not a very happy one. So my presentation is divided in three parts. In the first one, I will say a few words about marriage and family. In the second part, I will present the present European legal situation of family and marriage, identifying the cause of the weakening of the family and the marriage. And finally, giving, of course, examples from the case law of the European Court of Human Rights. And finally, I will say what should be done to change this trend. So why do we need family and marriage? Why people associate? Because family and marriage is a form of association of persons. The reason of existence of any kind of association is the incapacity of the person to accomplish alone his complete human development. And the first incapacity of the human being is the powerlessness of the child at his birth to arrive alone at his development as an adult. A child needs constant presence of his parents. In his education, he needs the complementarity and the difference between his mother and father and their collaboration. This is why family is the first form of society that the human person needs fundamentally. This is why family is the stable union of the parents for the education of their children. Other intermediary bodies cannot exist if there are no families to bring children into the world and to accompany them to their integral development through education. Therefore, family is the means by which it is assured the necessary education of children for their complete human development. Moreover, family is the source of life and the continuity of humanity, and also of other human societies in a country. The stability of family is fundamental. This is why the stability is guaranteed through the institution of marriage. If there are guarantees, there are also sanctions. So this is why we need an institution to protect the stability of family. Marriage is a perpetual and exclusive union between a man and a woman in order to found a family and to bring their children to their complete human development. Namely, the duty of parents to bring to life a conceived child before his birth and the duty to educate him after his birth. Therefore, the essence of marriage is the permanent union, the sexual difference, the openness to a new life, and the duty of the parents to educate their children. All those four characteristics have been recognized and protected by the states and by the international community through the human rights. Namely, the right of a man and of a woman to marry and to found a family, the right to life of the unborn child, and the right of parents to educate their children according to their religious and philosophical convictions. Those are natural rights which depend on the nature of the human being. However, we see that the characteristics of marriage and even its prohibitions are challenged at the European Court of Human Rights, at the Council of Europe, and at national level. It is requested the redefinition of marriage and the establishment of new human rights. For example, the sexual difference and complementarity between man and woman is relativized through same-sex marriage and multiple parenting. The lifelong union is replaced with free unions, civil partnership, and divorce. The openness to life of the man and the woman is challenged with a so-called right to abortion and other rights related to medically assisted procreation. The parents' duty and right to educate their children is replaced with compulsory sexual education in schools, with ban of homeschooling and obstruction of religious education in public schools. The prohibition of incest is in the way of being decriminalized and accepted as a new form of family. Regarding the causes of family crisis, there are two things that should be noted. The first one, the primary cause of the family crisis is not poverty or consumerism, as my friend also recalled in the synod last week. Those are predisposing factors. The primary cause is ideology, is the ideological vision about the human person. Second, it should be also remarked that even if those attacks on family started in the West, they are not typically Western phenomena. They are a deconstruction of the Western civilization and culture, built and impregnated by Christian values and tradition, in order to create a new world. Those are contracultural phenomena which originate from Marxism, that during time undergone some changes. Now, the revolution is not taking place in the economical field, but in the social and cultural field. And those who promote all those initiatives are ideological followers of Marxism. There is documentation stretching over decades demonstrating Soviet attempts to infiltrate the Western culture to support all movements that undermine morality. This Marxism was imposed in the Western society softly by cultural subversion and social engineering, and now they are coming back in the East. The aim was to transform the society in all its aspects, abolishing the existing values, concepts, and institutions of the society and replacing them with the Marxist ones. In the law field, this process was accomplished through what we call judicial activism. This is an instrument to operate changes through the reinterpretation and distortion of legal principles and the creation of new rights. At the European level, this was accomplished mostly by the European Court of Human Rights, which has a role to interpret the European Convention of Human Rights. Unfortunately, this jurisdiction interpreted it ultra vires or extra legem, according to a Marxist ideology. By doing this, the characteristics of marriage were relativized, the final purpose being their abolition. Thus, human rights are reinterpreted and new human rights are created. Some examples of forms of weakening of family and marriages are the following. Regarding the sexual difference and complementarity between the man and a woman, which are relativized, there are the attempt to legalize civil unions and marriage between same-sex persons and multiple parenting. It should be noted that there is no right under the Convention to confer a legal recognition to same-sex couples, be it under the form of civil partnership of marriage. Regarding the civil partnerships, steps were made to arrive to such a right under the Convention. Nevertheless, as long as there is no European consensus on the matter, the Court cannot go forward obliging all the member states, but only individual states according to their legal situation. To present, 3 main steps were made in this sense. The first one was made in 2011 in Schalkenkopf case against Austria, and it was the first step to redefine the notion of family life to include stable and cohabiting same-sex couples. The next step was in a case against Greece in 2014, when the family life was reduced to private life by the inclusion of the same-sex couples that were not living together in the notion of family life, and the obligation of legalization of civil partnership for same-sex couples if different sex couples can enter in such a partnership. And the third step was made in an Italian case this year, in which the court instituted a positive obligation on Italy to institute civil partnership for same-sex couples. This obligation is based on the Italian highest court's acknowledgement that same-sex couples enjoy private and family life, and therefore they should enjoy a legal status. Regarding same-sex marriage, it would be even more difficult for the court to declare such a right, interpreting the Convention. Both Articles 12 and 9 of the 12 of the Convention and 9 of the European Charter of Fundamental Rights guarantee and protect the right to marriage and to found a family as it is defined by the national law. Therefore, the member states are free to define marriage as they want. Nevertheless, once they define marriage also as between same-sex persons, this marriage will also be protected by the Convention, in the same way as marriage between a man and a woman. This is to see how important it is to defend marriage at national level and not wait the cases to arrive at the court. So the highest court should be very carefully followed, and also the legislative in a country. There are three cases, important cases on marriage at the court. In 2014, the Grand Chamber of the European Court of Human Rights held that there is no obligation for the member states under Article 8 of the Convention to allow same-sex marriage. 1 year later, the court rejected a complaint of the applicants regarding the right of same-sex couples to marry. This is the Italian case. But there is a pending case, a pending Italian case that can change that trend. It concerns 6 Italian homosexual and lesbian couples that, after practicing a tolerance for marriage abroad, sought the transcription of their marriage by the Italian authorities. They were refused. Nevertheless, the Italian Court of Cassation judged that as same-sex couples enjoy family life as any other couple, they have the right to the same treatment as the married couples in Italy. In other words, they have to have the same rights as married couples. And this means that, after all, they enjoy the effects of their marital status contracted abroad, but without having the status of married persons in Italy. But once same-sex couples will have the right to claim and to have the same treatment as married couples in Italy, the next step will be to confer them the status of marriage, as for the same rights require the same status. Now, multiple parenting. In 2013, in an Austrian case at the European Court of Human Rights that was already mentioned in X and others against Austria, the European Court of Human Rights operated a redefinition of the legal parents, considering that the parents of a child are not necessarily two. his mother and the father, his mother and his father, but many other in the same time. And after this judgment, the Austria changed its civil code, allowing the partner of the mother of the child to adopt and become a legal parent of the child at the same level as his mother and his father. Second, the lifelong union between a man and a woman is relativized by the legalization of civil partnership between a man and a woman, and by the right to divorce. Not only same-sex couples request civil partnership, but also different-sex couples. This is to achieve a complete equality and equivalence between couples that are completely different. And finally, to have the same protection. It is emptying the meaning. It is emptying of meaning of the finality of the couple composed of a man and a woman, and the essence of their difference and complementarity. And you will be surprised, but actually there is such a case at the European Court of Human Rights. A different-sex couple is requesting to the court the right to conclude a civil partnership, as same-sex couples can do in Austria. They consider themselves discriminated against on grounds of their sexual orientations by being denied access to a registered partnership. They stated that marriage does not correspond with their idea of partnership. They say that civil partnership is more modern and lighter than marriage. By lighter, meaning easier. It is easier to divorce, and they can have more sexual freedom. Now, the right to divorce. The permanent union between a man and a woman is also challenged by the creation of a human right to divorce, although there is no human right to the dissolution of marriage. Steps were already taken in this way in cases regarding the right to remarry after a divorce, in which the court said that the conditions of the divorce proceedings can constitute a violation of the convention. And to give an example, the court considered that the fact that the internal law allows the spouse who is not at fault to oppose divorce can pose a problem under the convention. Third, the openness of the man and of the woman to a new life is challenged by the request of a right to abortion, by the right of parents to decide on the fate of their in vitro embryos, and by forced sterilization, for example. The right of the parents to educate their children according to their philosophical and religious convictions is undermined by the compulsory sex education in schools, the ban of homeschooling, and the obstruction of religious education in schools. Regarding the compulsory sex education in schools, none of the parents succeeded in obtaining the possibility to opt out their children from those classes. They had to prove that the content and the manner of teaching was not objective and had the purpose to indoctrinate their children. Moreover, as far as they could enroll their children in private schools and to educate them outside the school, this cannot be considered as a violation of their right to educate their children. Prohibition of incest is weakening the notion of family life, as those relations are protected by the convention, at least, as the court says, at least under the notion of private life. So what should be done? Even if some of the notions and rights of the Convention were or are about to be abusively interpreted by the court, some others are in conformity with the human nature and the finality of the human person, acknowledging the characteristics of marriage. Those should be used at national and European level to tell what marriage and family is, to denounce the ideological interpretation of the human rights by the court, and to recall the good principles and to affirm that same-sex couples are objectively in a different situation than different-sex couples from the point of view of family law, and therefore there can be no discrimination between them. Same-sex couples fall within the scope of private life and not of family life. Marriage is always a means to found a family. This is why only a man and a woman can marry together. Marriage is an institution. It guarantees the protection of children and it serves the common good of the society. Legalizing same-sex civil partnership or marriage has to be justified by a public interest. Conferring the same rights to all couples and legalizing civil partnership will always lead to the legalization of same-sex marriage. There is no right to dissolution of marriage. Parents have the fundamental right to educate their children according to their religious and philosophical convictions. Thank you.